Hello, today is September the 10th, 2009, and welcome back to my program. My name is James Stratton, and I help people through some of the toughest times in their life through a process called mediation. Mediation is all about restoring relationships and reputations in a confidential, non-threatening, and a non-judgmental environment that usually costs a lot less expensive than going to actual court. Now, unlike going to court, which is a very public event, one of the things that we do here today is we take the super complex and we make it super simple. Each week we go through a court case that has actually been filed in one of the courts, and we dissect it and we study it and see how mediation might be able to help the parties reach a more amicable decision a lot sooner. Okay, so here we go. This week we've been studying the dreaded sexual harassment in the workplace case. Now, when I was a kid growing up in the 70s, and I think I just dated myself there, but when I was growing up in the 70s, want ads, you go look in the want ads and you would see offers for employment for secretaries. And I remember asking my mom, did they just misspell that? Didn't they mean secretary? And she'd say, yes, they meant secretary. Because, we were coming out of a different time back then. Today, we live in an environment where that kind of conduct is not welcome in the work environment. And in fact, we run into many cases where a person just can't help but blur the professional relationship with their personal relationships. And we run into these sexual harassment cases. And as you recall, on Tuesday, we talked about a case in which a young lady went to go apply for employment as a waitress at a restaurant, and she was accepted for employment, and then later she was terminated. Now, her claim is that she was sexually harassed in the workplace, and that if it wasn't for the fact that she was not accepting the sexual advances of her employer, she wouldn't have lost her job. And so she's charging the other person with assault. Now, of course, it's a civil and not criminal, but she's charging them with assault and with sexual harassment in the workplace and wrongful termination. Now, keep in mind that this program is not intended to provide for legal representation at all. If you have found yourself in this situation, I would advise you to go seek legal counsel from a licensed attorney. You can do so by going to your local bar association and asking for a referral. Or if you're in Texas, just call up the Texas Bar Association and provide you with a referral to a qualified attorney in your area. I'm a qualified mediator, and that is my job, is to teach you how mediation can help you in these situations. Okay, so yesterday we actually looked at what the plaintiff is bringing as a charge against the defendant. And so today we're actually going to look at what the defendant's position is and what the defendant will have to do in order to prove their position. First, we have to look at what the elements are. In any civil case, any charge you bring is broken up into elements. And so, remember, she brought the charge of assault. Well, what is assault? Many people think that assault consists of an unwanted touching. Somebody pushes you, shoves you, hits you, and that's assault. And yes, that is. But it can also be a threat of an assault as well, in which a person makes a threat to do violence against another person, where the person who received the threat believed that the person making the threat could actually have done it. Okay, so it becomes, what does the person being threatened think, not what the person who did the threatening mean. So keep that in mind. So what are the damages as a result of that? Well, if you're found for assault, then the damages can be obviously ordinary damages, but also compensatory and exemplary damages. In other words, our society doesn't tolerate that kind of thing. What's the next one? She claims sexual misconduct in the workplace. So what is sexual misconduct? It's unwelcome sexual advances, request for sexual favors, and other verbal or physical conduct of a sexual nature that's unwanted. Okay. Along with that, it can be broken up into two different parts. Either it's called a quid quo pro or a hostile work environment. In a quid quo pro, employment is based on a submission to a conduct as condition of employment, or forms the basis of an employment decision affecting the hiring of that individual. So in other words, if the employer thought in their mind, well, I'm going to hire this person with the intent of asking for sexual favors, or if they make it clear that the condition of their employment is based on sexual favors, that can be a quid pro quo. Okay? Hostile work environment is where a person uses unjustified measures in order to make a person's work environment or work tedious or intimidating or hostile. Okay, those are the two areas of it. Now, along with that, all it takes is a preponderance of evidence to prove any one of these elements. Also takes a preponderance of evidence to disprove them. Now, what is a preponderance of evidence? A preponderance of evidence means that is more likely to have occurred the way you stated rather than not. It's not much evidence. Okay, so it's not like we would find in a criminal case, which means that it's overwhelming evidence in favor that you did it. Just a preponderance of it. Okay. Now, not to be undone, as you'll often find in these cases, defendants will often countersue. Always remember, the burden of proof goes with the person making the charge. And even when a person files for a countersuit, they have now switched themselves into being a plaintiff in a sense. So now what they've done is they've charged the other person with a charge. In this particular case, the defendant has charged the plaintiff with committing defamation. What is defamation? Well, the elements of defamation are a statement that causes harm to a reputation. It's published, whether it's spoken or put in writing, it doesn't matter because there's different categories of it, to a third party. So can you make a defamatory statement to a person in private? No. It has to be communicated to a third person. All right. Of which the publisher or the speaker had knowledge or should have known that the nature of the communication was false. Okay, what are the damages of it? Well, you have actual damages. You have, compensatory damages, and in some cases can be exemplary damages. So, those are the issues that we've got here in front of the public, or within this particular case. Tomorrow we're going to look at how did this case turn out? How long did it take to get there? And how mediation could have maybe helped these people get along better. Because remember, there's always secondary problems as a result of this. There could be damage to a business reputation that may cause them to go out of business. There could be damage to the employee for making the charge, even if they're right. Now you can affect the person's future employment. So we're going to take a look at that and see what the repercussions could have been. If you have found yourself similarly situated as the people in this case have been, you make a comment to me at my blog at www.whoisjamesstratton.com/blog1. I'd love to hear from you. If you found yourself in this situation and you'd like to talk to me privately about it, where it doesn't get out that way, you can email me at james.stratton@interventionmediation.com. I answer that email and it is private. I do not let that information out in the public. I look forward to seeing you tomorrow. We'll wrap this case up and we'll be done for the week. Have a great day.